decision on this matter. My oral comments will be brief. The augmented by written disposition. The board's order will be to grant the motion, effectively dismissing the appeal. A very brief way of explanation. Let me give some context first. And I don't think I can top it better than the way Mr. Fairbrother said it. Without a proponent, without a project, there is nothing to plan for. And I hope I got that right, because Mr. Fairbrother did repeat it 3 times. And let me say that whether it be council, whether it be the board, and I'll speak specifically for the board, whenever the board has to consider planning applications such as an official plan amendment, a zoning bylaw amendment, I'm going to be specific to this type of facility. The public health and safety has to be of utmost importance. The board would not entertain making a decision on either of these planning applications not having that information. Council also has not had the opportunity to have that information, and the reasons for that don't matter at this point. Council has an obligation to consider that information before they make a decision on the ultimate project should one be coming forward. This is a new application, and although counsel for the appellant may see this as a situation where his client assumes the application, the project, so to say, the individual components of the zoning bylaw amendment, the official plan amendment, the board is not convinced of that. This is a new project. This has to be a new project. It has to start from the beginning. And as Mr. Fairbrother, I think, stated, there is nothing to stop another application for this type of facility coming forward. But at this point, in the board's consideration, there is no planning application to be appealed. There is no planning application put before the board. I can tell you that the board absolutely would not approve an official plan amendment or a zoning bylaw amendment minus the information, particularly with respect to the, I didn't write it down, but the public health and ecological assessment report. And should that be brought to a hearing, it would be quite likely that the board's direction would be that the whole matter had to go back before the council. Again, the board's disposition is that the motion is going to be approved.
Excuse me.
Walking out.
whether in fact we do or do not have a review. The board is going to defer request and its position with respect to party and participant status until the disposition on the motion is made. In the event there is an oral disposition today, the board will then continue the pre-hearing conference and consider the matter of party and participant status. In the event the board finds it necessary to reserve on this decision, future pre-hearing conference will have to be scheduled, and that at that time party and participant status will be determined. Okay, let me just do a little housekeeping here. See the documents I have are correct. I have an affidavit of service notice filed by the municipality. I marked that as Exhibit 1. Mr. Fairbrother, an affidavit of service on this service of the motion.
I do not, Madam Chair, but everyone here has served taking surveys already. So, and I can undertake to provide that to the board's files.
Okay. I would ask you to undertake to do that. I will mark it as Exhibit 2.
Thank you.
Motion record of the municipality is Exhibit 3. I have a response to the motion from Entech-REM Canada, who also have advised that they will not be participating in today's matter. Number 4 and number 5, response to motion by 1804837 Ontario Inc.
Service of responding service.
And that will be Exhibit 6. Are we ready then?
Yes.
They're telling me they can't hear. I will try to speak up. Can somebody at the back kind of give me a wave if you can hear me now? Okay. And give me a wave if I get speaking away from the microphone. Mr. Fairbrother, will you just try yours to see that it's projecting?
Testing 1, 2, 3.
Can you hear Mr. Fairbrother?
Okay, I'll speak louder when we get to the salient part. Madam Chair, what I did was, and I'm not sure if it's going to be consistent or not, given the number of individuals who indicate they would be here today. I just took the motion materials that we filed and you've already marked as an exhibit, plus the responses, and prepared a record so that it would save me 3 or 4 pages if you would like that.
That would be very helpful to me. And I will mark that as Exhibit 7.
I'd also like to tender as the next exhibit an affidavit from Jennifer Savini in my office, who just simply attaches 2 documents. One of them being a copy of the registry records showing ownership of the subject lands as of yesterday. And that's Exhibit A, and Exhibit B to her affidavit are excerpts from the environmental screening report. The environmental screening report is a document of public record and was put in by the proponent Entech-REM. I will be referring to that in my submissions solely for the purpose of indicating to the board that the energy from waste gasification facility that Entech-REM is proposing was proprietary. You will see the relevance, I hope, as I go through my submission. So I'd like to offer that as the next exhibit. Can I provide a copy?
Thank you. Exhibit 8.
And lastly, you can tell it's March break and that I have a terrible assistant helping me with this, namely myself. I've put together a very rudimentary document. Well, this just is excerpts from some of the legislation that I will likely refer to in my submission. So I offer that as the next exhibit, and again, I provide copies to my friends. Thank you. So with that, Madam Chair, I'll begin with my submissions. As you have noted, the motion that we have brought forward is a motion to dismiss this appeal without a hearing under the grounds permitted under the Planning Act. And in the motion materials that we filed with you, I essentially raised two categories, if you will, of grounds. One related to the prematurity argument, which would speak to the timing of the hearing if one was to proceed. But the other and fundamental one is dismissing the appeal without a hearing. I do want to start, however, with the prematurity argument, simply because Mr. Mazar and his Mazar. Mr. Mazar has, in his response material, has dealt with some of the prematurity grounds that we brought forward. So I'll deal with that first, and then I will deal with the grounds for motion to dismiss. Essentially, what we were indicating was that should the hearing be conducted in this matter, it would be premature to do so until all environmental reports have been completed. It is common ground that a report with a long title called Human Health and Ecological Risk Assessment report, the acronym is just as hard to say, HHERA. I'll refer to it as the Health and Ecological Report, has not been completed. Mr. Mazar indicates in his notice of response that council is stopped. His position is that council is stopped from raising that as a ground for dismissing the appeal. And that's from his materials. I want to be clear, that's not a ground that we rely on for dismissing the appeal. It's a ground we rely on for the prematurity argument. And so I'll deal with it in that context. There is no dispute. Council did not have that report. It hasn't been done. It hasn't been completed when they decided to refuse the application. But my submission is that regardless of whether or not council should or should not have refused the Planning Act application without that study, the OMB now, by virtue of the appeal, has an independent jurisdiction to exercise. It's basically irrelevant to my client, the council, what they decided or did at that time. The OMB has an independent jurisdiction. And in my submission, the OMB can decide, and I submit should decide, not to conduct a hearing until such a report, in fact, until all reports are completed, and you have all that evidence in front of you. As the name suggests, the Human Health and Ecological Risk Assessment Report is a document that would examine anticipated impacts on human health and the ecological environment. It is well settled law that the OMB, as part of its mandate, considers environmental impacts in reaching land use decisions. It does not exclude environmental considerations. Authority for that, of course, is found in the Planning Act, which I provided in the document book. And this is found behind the green page, the first green page in Exhibit 9. These will, of course, be well known to you, but just for your records. Section 2 indicates, and I'll just paraphrase, the Municipal Board, in carrying out their responsibilities under the Act, shall have regard to, among other matters of provincial interest, such as A, protection of ecological systems, H, orderly development of safe and healthy communities, and O, protection of public health and safety. And in my submission, those are all relevant, and HHERA would be relevant to that end. Not only in my submission does the OMB have an environmental mandate, as are indicated under the Planning Act and generally, but in my respectful submission, the OMB would not want to reach a decision based solely on land use planning evidence that may fail to take into account important findings out of the whole environmental assessment process. Now, the appeal in this matter was filed by Entech-REM and a number company, 1804837 Ontario Inc., which is shown in the style of cause. I'm just going to refer to it as the number company. And the landowner's response is that they want to adopt that appeal and move forward. The grounds for the appeal are found in my motion record at tab 2, tab C. This is the appeal from Lake Castle's Mr. Swinton on behalf of the appellant, Entech-REM and another company. And if I can ask you to turn a number of the pages in the upper right-hand corner to page 37. And these are the grounds and reasons that were put forward by Entech-REM. And I'm looking to start with paragraph 1. And I'm going to start with the last sentence. Council's direction to hold the public meeting and to determine the applications proceeded on Council's direction, despite objection by the appellant that this was inappropriate and would deprive Council and the public of the broadest understanding of the proposal. What he's talking about there is going ahead, as Council did in July, of making a decision without this report. And what I found important and useful was the last phrase, it's inappropriate and deprive Council and the public of the broadest understanding of the proposal. My submission to you is the fact is that statement is equally valid as it was with perhaps the Council, but absolutely valid to this board now with your independent jurisdiction. And I would adopt that as part of the submissions, that it would be inappropriate and would deprive Council and the public of the broadest understanding of the proposal to proceed with a hearing in the absence of such a report. Similarly, in the same paragraph, about 4 lines down, you'll see a sentence that starts, "It has always been." So paragraph 1, 4 lines down, "It has always been." It has always been the appellant's position, as concurred by municipal staff, that a complete assessment of potential environmental impacts should be undertaken and available for scrutiny by the municipality and the public before the applications were fully considered. Again, this statement was made in the context of the Council decision, but it is no less true and no less applicable in the context of an OMB hearing, and I adopt that as part of the appellant's own reasons as part of our submissions as to why this hearing would be premature if it were to proceed. The respondent to the motion, Mr. Oates, filed 2 affidavits, and at tab 6 of the motion record I provided to you, page 79. There's an affidavit of Mr. Reusing, I hope I'm pronouncing his name correctly, with Conestoga Rovers. Conestoga Rovers, the record indicates, were the consulting firm retained by Entech-REM to do the environmental screening report. And Mr. Reusing states in paragraph 7 on page 80 of his affidavit, in a normal and usual course, where an HHERA is incomplete, Council for the municipality will not provide a decision in the rezoning and official plan amendment for power generation and recycling EFW until such reports are available. Once again, that statement equally applies to the OMB and the independent jurisdiction that you have now. It would seem, of course, we'll hear from Mr. Mazar, but he's taking the position that the OMB should proceed, that Council is now, my client, municipalities, have stopped from raising this, and the OMB should just simply proceed in the absence of such information. If indeed that is his position, I think it ignores the independent decision-making function of this board and the mandate of the board to consider all relevant evidence. So that's really all I have to say about the prematurity argument, because essentially I hope that any consideration of deferral or prematurity is unnecessary, because I believe there are compelling grounds to dismiss this appeal without a full hearing. And I'd like to deal with that now. Madam Chair, there has been a significant development as expressly confirmed in the notice of response to the motion that was filed last Thursday by Lake Castles, the solicitors for Entech-REM. And you'll find this at tab 3. This is the response to the motion filed by the solicitor on behalf of Entech-REM. In paragraph 1 states, Entech-REM Canada Inc. no longer has an interest in subject lands as defined in the notice of motion. That is critical for reasons I will expand upon.
We can't hear very well back here. I don't know if there's a microphone being used, but it's really hard to hear.
I'm sure what else I can do.
Well, it is a large room and the acoustics might not be ideal. I think we got the microphones cranked up here as high as we can go without a swell.
I don't know if that's any better. I'll try that. I'm not starting over. We're just getting to the important stuff now anyway. So I directed the board to the notice of response that indicates Entech-REM no longer has an interest in the lands, and this is consistent with the affidavit evidence that's filed by the respondent to the motion. If I may, essentially the respondent, Mr. Oates, indicates he's cut all ties with the Entech-REM, wants to proceed with the Planning Act application, but Entech-REM, as a proponent, no longer has any interest in these lands. So we reach a fundamental and critical fact in the matter, and that is there is no proponent, there is no project. You're being asked to move forward and establish a hearing date for a land use for which there is no proponent. Furthermore, when I received the information late last week in response to the motion, I began to wonder whether or not anyone could just pick up the proponent's case and run with it. And I'll come to this in a moment, but Mr. Oates says he's had interest, he's been approached by others. But if you have a look at the affidavit of Ms. Savini in Exhibit B that I provided to you, that's Exhibit 8 in tab B. This was a 1,700-page document, roughly. I made the decision not to include it all. And besides, a lot of substantive evidence in there, which isn't the purpose today. As I indicated, the purpose in bringing this forward is to demonstrate to the board that Entech's gasification facility and process is proprietary, and no one's going to be able just to step in and pick this up and run with it, and of course Entech's out of it. So let me take you to the parts from the excerpts here that demonstrate that submission. So on page 2, you'll see this is definitions and acronyms, and at the bottom of the page, Entech-REM. Entech-REM Canada Inc. is the proponent of the proposed facility. Over the next page, facility. Facility is defined to mean the waste management, recycling, and power generation facility proposed by Entech-REM at the beginning of the environmental screening, referred to as the materials recycling and advanced gasification facility. The facility name is now being clarified in response to public input. So the facility itself is proposed by Entech-REM. Over onto the next page, owner is defined, and the owner is Entech-REM Canada Inc. And on the same page, there's a definition of the phrase
pyrolytic gasification, which is defined as the process of thermal conversion of waste to synthetic gas, syngas, in the near absence of oxygen, using for this facility the Entech-WT gas/RES trademark process. On page 9, at the bottom of the page, section 1.4, the project proponent is Entech-REM Canada Inc., which will own and operate the proposed facility. And perhaps most importantly is page 10. It's the first full paragraph that says Entech-REM controls the North American license for the Entech-WT gas/RES trademark pyrolytic gasification technology owned by Entech Renewable Energy Solutions, Pty Ltd. Madam Chair, it is absolutely clear that the proponent in this case was the owner of the facility, proposed facility, has proprietary interest in the gasification process, and there is no evidence filed by Mr. Oates or anyone to suggest that someone else can just pick this up and run with it. So again, we come back to that fundamental observation. We have a Planning Act application with no project, no land use being proposed. Mr. Oates does indicate that he has been approached by 3 other parties, but that's all it is, he's been approached. Given the proprietary nature of the Entech-REM gasification process, in the event that another EFW proponent ever does materialize, and there's no certainty of that, that proponent is undoubtedly going to have to submit a fresh application, which may involve substantially different land use and environmental considerations. A phrase that is well known to this board is the phrase of pre-zoning lands or pre-designating lands. And in my respectful submission, that's where we are right now. Without a proponent, Mr. Oates is, by seeking to continue the appeal, is seeking to pre-designate and pre-zone these lands for an energy from waste gasification plant. And there is no proponent for that any longer. In my view, pre-designating and pre-zoning these lands for such an intensive land use with significant potential impacts on the environment and human health in the community is entirely inappropriate and does not represent good planning. As the board knows, under the official plan sections and the zoning sections in the Planning Act, which are included in the materials, but I won't take you there because they're well known to you, I'm sure. One of the grounds for dismissing an appeal without a hearing is where there is no apparent or genuine land use planning grounds. My submission to you is that without a proponent, there can be no genuine land use planning grounds upon which a board could allow an appeal. Simply stated, without a proponent, without a project, there's nothing to plan for. I'd like to repeat that. Without a proponent and without a project, there's nothing to plan for. Without a proponent, there is no prospect of any environmental evidence that could be proffered to the board. At this stage, there's no affidavit evidence to indicate that should a hearing move forward, that the appellant is in a position to proffer planning evidence, which has been a grounds in a previous case, and I can provide you the citation later, where the board has rejected proceeding to a full hearing, a decision of Ms. Zudema. Another ground for dismissing an appeal without a full hearing is if it would be frivolous. And in my respectful submission, to proceed with a hearing in these circumstances would be frivolous, because, to be blunt, it'd be a waste of time and resources of the OMB, the municipality, the public, and the parties. As I've already provided my submissions, if there, and I think it's a big if, but if there is a new proponent, it is certain, because of the proprietary nature of the Entech-REM facility, that they will not be using that project. As a consequence, a new proponent, if one ever materializes, would have to file a new application that would involve different technology, can't use Entech-REMs, it's proprietary, different environmental effects, and different land use planning considerations. We're back to square one, essentially. Consequently, if there is a proponent in the future, any new application should go through the normal process prescribed by the Planning Act, starting with consultation, public review, a decision at the local level, and, depending on circumstances, any appeals to the board. In looking through the Planning Act, it occurred to me that there is yet another ground for dismissing this appeal, which I think is little used but applies in this case. And that is the ground, and for your reference, Madam Chair, it's in the materials, but it's section 34, bracket 25.1.1. And that's the ground where the application to which the appeal relates is substantially different from the application that was before council at the time of its decision. My submission to you is that the appeal that is before you today, as it stands right now without a proponent, is substantially different from the application that was before council. The decision that was before council had an actual proponent. If this matter was to proceed to a hearing, it would be substantially different because there would be no proponent. It would essentially be just a blank pre-zoning. The obvious question that must be asked as we stand here today is, what if no proponent ever comes forward? If the appeal is not dismissed, the matter remains in limbo. In my view, that is not in the public interest, given the significant public concern over this proposal. I've described it as a cloud of uncertainty and concern. And as evidenced by the large number of individuals here today, they are deeply concerned. And my council is unanimous in its concern over this proposal and just remaining in limbo. It's an uncertain status. In terms of prejudice, if you were to grant my motion, there actually is no prejudice in my respectful submission to the owner. There's nothing in law to stop him from resubmitting a fresh Planning Act application if and when a new proponent comes forward. But the prejudice to the municipality, Mr. Petch, who is here and has indicated in his correspondence on behalf of a developer who is concerned about the impact on sales of homes, Mr. Gillespie, who's here on behalf of a ratepayers group, there is substantial prejudice in just having this thing remain in limbo and should outweigh any prejudice, which is pretty insignificant in my view, to the owner. I did file as tab A to Exhibit 8 of Ms. Savini's affidavit, a copy of the abstract from the registry office. And it shows, as of yesterday, that Mr. Oates is not the owner of the subject lands. It shows that in 2009, Mr. Oates sold to the numbered company, being the appellant, one of the appellants, and that Mr. Oates took back a mortgage for $4.9 million. In fairness, as I always strive to be, I've had a discussion with Mr. Mazar this morning. He indicates to me that Mr. Oates takes the position that he is the owner because he has commenced default proceedings under the mortgage, and it just hasn't shown up under power of sale, I believe is what he told me. Mr. Mazar can speak to that. So that he is the owner because he's taking the property back for default under the mortgage. I accept Mr. Mazar's submissions in that, but I just wanted to, I have made that part of the submission. I didn't want to in any way misrepresent the information that I have from the registry office or what my friend has told me. At the end of the day, it's interesting that he's not the registered owner, but I don't think it's fundamental to my grounds for dismissing the appeal. I'll conclude by saying that at the opening of my submissions, I indicated to you I felt that there are substantial and compelling grounds for dismissing this appeal without a hearing. The former proponent, Entech-REM, as agent for Mr. Oates, made a Planning Act application, but it was based on proprietary technology for a gasification plant. The former proponent is no longer involved. There is no longer a project upon which that zoning was to have been based. The OMB is permitted to dismiss an appeal without a hearing when there are 1, no apparent land use planning grounds, 2, where it's frivolous, and 3, where it relates to, the appeal relates to a matter that is substantially different from the application that was before council, all of which I've submitted. In my view, any one and all of those grounds are reasons to dismiss the appeal without a hearing. So again, I indicate that the prejudice to Mr. Oates is insignificant, particularly in weighing it against the public interest in having some certainty, and I ask that the appeal be dismissed without a full hearing. Thank you.
Can you hear me? Is everybody fine? It's wonderful to look at all these issues. Let's go to the fundamental problem that you face today, Madam Chair, is who caused the problem in the first place? Council proceeded to make a decision without all the information in front of them. No matter how you cloak it, how you change it, how you want to wrap it in whatever system you want, they caused the problem that puts it in front of you today. They proceeded without all the information. And that is precisely one of the grounds that has been set out in our notice of appeal. We're entitled to have a full hearing on that issue. It shouldn't be dealt with on a summary basis. It should be dealt with full explanation of it, full evidence in front of you, so the board knows the true state of affairs that were made in this unfortunate and unrealistic planning decision. What our suggestion is, this is not a position that should be dismissed on just a summary basis, first of all. And my argument is to you is council chose to proceed in law their stock. They cannot now come back and say, wait a second, you didn't have all the information here, so you can't proceed with your appeal. It was their decision. Every other issue was approved by the staff and recommended by the staff to proceed to allow the rezoning and also the change to the official plan. Save and except for this, the HHERA report. And again, why wasn't it there? Council chose on their own accord to proceed in the absence of it and make a decision. That shows a total disrespect for the citizens of Port Hope. They should have properly investigated it before they proceeded. Because health is an important issue. But evidence of it is something that they should have considered, and they didn't. But that's not the owner's problem or Entech's problem here. It's the municipality who created this problem in the first place. Let me then address the quality of the evidence that's in front of you right now. We have evidence from Secretary Mr. Fairbrother's office giving facts. We have the direct evidence of Mr. Oates, who's knowledgeable about what went on, an engineer, environmental engineer, who says and contradicts most of the fundamental issues that have been raised in this motion. You have to balance that out. There is no direct evidence of a number of these things that have been purported to be put in front of you as reasons why this appeal should be dismissed on a summary basis.
Can you be more specific with me, please?
Sorry?
Can you be more specific with me?
Yes. Number one, there's no explanation of what went on at the council hearing. Mr. Oates does give an explanation that why the decision was made and what wasn't in front of council. There's nothing there that in the affidavit of the municipality suggests that.
Okay, I want to be clear. Your submission is that, I believe you so stated it in your response to the motion, that you are contesting some of the information you're contesting some of the information that's been provided in the affidavit.
Correct.
Can you be specific as to exactly what that is?
Well, the answer is here, basically, Mr. Fairbrother's secretary was not at these meetings. She had no knowledge of these meetings. She's looking at correspondence and drawing conclusions and directing you.
Can you tell me exactly what you deem to be incorrect in the affidavit?
If I go to the affidavit of Pamela Orsburn,
I just need to get to it.
it's found at tab 2 of Exhibit 7.
Yes?
There's nothing there that explains the decision of the municipal council. There's nothing there that describes that, in fact, that the decision was made in the absence of the HHER report.
Okay. If I may have reconciled correctly, I believe that your submission was that you contradict certain aspects.
We contradict, and as a matter of evidence, which are you to believe someone who has direct evidence and there's no basis for what she's saying?
Council, surely you're aware that the board is well acquainted with these matters and affidavits.
Correct.
And Council, you clearly stated that you are contradicting, unless, again, I wrote that down correctly, you are contradicting at least parts of the affidavit.
Correct.
When you go to the numbers, the numbering, and explain to me exactly which one of those points you're contradicting and in which way you're contradicting it.
So I'll go again. Paragraph 7 of her affidavit.
Yes?
In terms of, in paragraph 8, I'll put them together. Again, there's no evidence before you other than the evidence of Mr. Oates and Mr. Riesling about the basis for the council denying the application. And an explanation of it, and why it occurred.
Okay, so can you direct me to in 7 and 8 where Ms. Osborne suggested that there was?
Well,
What
she
exactly is she, What exactly is not correct?
Yeah, it's inaccurate. She hasn't explained why the position of what council took. And the evidence is before you. Direct evidence of Mr. Oates, Mr. Riesling is the basis why this council prematurely took this on, made the decision in the absence of the HHERA, and that this is out of the normal course. That's found, and they have direct evidence. They're knowledgeable about them. They were there and present.
I don't think there's any dispute of that. Quite frankly, you're aware of the documents that the board must be provided with when an appeal is launched.
Correct.
And the board does have the written appeal of Entech-REM.
Right.
And I think it even states in there that they feel the decision by council was the fact that it was before council board decision was premature. What information is it that you think the board doesn't have
I
that
get
it needs to have to make a decision on the application?
Well, first of all, there's an explanation why there's no, there's in the materials, there's evidence that is before you that the HHERA report was withdrawn. And there's an explanation of that doesn't, there's a clear explanation. There's a difference of view on that. There's different evidence.
Okay, I believe I've seen a letter from the Ministry of the Environment with respect to that.
Correct. And then there's the evidence of Mr. Oates and Mr. Riesling, particularly Mr. Riesling, who was dealing with the environmental issues, who said that on the advice of the ministry, the HHERA report was withdrawn after the appeal was launched.
Okay.
And I want you to take that certainly is not reflected and explains the reason why it was withdrawn.
Well, I'm not sure that it's either here or there with respect to the planning merits. I have the letter. I can go to it in the file if you would like to show me what's incorrect in that letter or what's incorrectly documented somewhere else.
But one of the bases for arguing from the municipality standpoint is that look at the application for the HHERA was subsequently withdrawn
After the decision of council.
after the decision of council. So the question is, what's the basis for that? There's an explanation given for that.
I guess relevancy is what I'm concerned with.
Well, and it's quality of evidence. The evidence that's before you from the municipality is not, where's the source of the information? We have someone who is directly involved in environmental aspects and knows why these things were done. And so the quality of evidence, the direct evidence, should be taken into account and be believed over that of someone who has some information but is used just attaching a whole bunch of letters to it and saying this is what the solution is.
I'm trying to understand the relevancy of your submissions to the matters before the board. The matter before the board right now is a motion to dismiss the appeal.
Correct.
This board is not considering the planning merits at this point. Mr. Fairbrother made submissions as to why the appeal should be dismissed. I need you to respond directly to those submissions, or help me understand how the submissions that you are making relate to the matter that's before this board at this time, and that is the motion to dismiss.
Well, one of the things that you have to consider and to decide is which story you're going to believe with respect to the events that have taken place in regard to the motion to dismiss. There's an explanation given why this report wasn't proceeded with, but it was taking taking place?
Well, I need to know the relevancy of that report, because quite frankly, the decision of council was made in, I believe, August?
July 29th.
July. It was October, November that was withdrawn. And the ministries provided letters. But quite frankly, I have no idea what the relevance of that is as to whether or not the appeal should be dismissed. But I must take it at face value what the ministry wrote in that letter.
And I understand why, but I'm giving what's contained in, especially Mr. Riesling's affidavit, is the explanation of why that report was done. And this goes on to whether you're going to ultimately deal with this on a de novo basis. Because if it is, then it explains why the report was done. And that's not the basis for dismissing the appeal, because the report was withdrawn. But the implication is, I just want to make sure that's clear in your mind, that there is an explanation for it and why it proceeded. Now, again, the OMB has, twofold jurisdiction. One, to look at it on an appeal basis, but also deal with things de novo. And certainly, this information could, in the absence of going forward, we could simply continue to produce that report, ratchet it up again.
Well, let me clear things up. Hearings of the board are denied. And the board makes its decisions based on the land use or whatever technical evidence that's before it's in support of the appeal.
Right.
The board gives consideration to the decision made by the local planning authority, that in this case being the council, and the materials they had before them. But ultimately, the board makes the decision based on the evidence that's before the board. It's a hearing to know.
Right. Now let me address the issue about REM's position here. And again, this has just come to my attention today. There's excerpts from a report, and Mr. Fairbrother has indicated that somehow REM has these exclusive rights. And if you look at the materials that he's filed, there is no way that it says that. He's pointing out various aspects of this ESR report, which in fact doesn't say they have the exclusive rights to this. And I'm going to point this out to you, and if you read it carefully, it says Entech-REM, this is at page 10 of the excerpt, controls the North American license for Entech WT gas RES trademark pyrolytic gasification technology owned by Entech Renewable Energy Solutions, Private Limited, Entech. One cannot draw the conclusion that no one else has this technology or equivalent technology or the same technology. And you're asked by Mr. Fairbrother to find that as part of the motion. In fact, this doesn't say that. It says it has this license. And in fact, I don't think, from what my understanding, and I've had some discussions with some parties from REM, and this is not exclusive.
We don't have any evidence. You've had discussions with REM. Madam Chair, I'm just going to object to what I anticipate my friend is about to say, because he prefaced it by saying he's had discussions with REM. There's no affidavit evidence of any discussions with REM, so submissions have to be based on the affidavit material and the documentation provided to the board.
Council, I'm sure you're aware.
I got this morning. Then if you want, I'll ask for an adjournment and we'll file material from it.
Well, the board's not going to grant an adjournment. As council, you have a responsibility to bring forward to the hearing any evidence that you may think may be helpful on the matter. And I guess that means that you maybe have to guess a little bit at what the possibility is. But as a member of the bar, you are full well. This is a motion before a proceeding. And hearsay evidence isn't any more acceptable from a member of the bar than it is from any other individual involved. And you're quite aware that you would need an affidavit.
All I'm saying to you, pointing out to you, is that my friend has drawn a conclusion from taking excerpts from a report.
He has put that before the board for the board's consideration and determination of this matter.
Right.
It is the evidence that he has put before this board.
And I'm going to suggest to you that it doesn't say that. It doesn't say that it's exclusive technology, guys.
Well, I'll accept that submission and you said, make the determination.
With respect to the issues about a proponent, there's evidence from Mr. Oates that in fact he has interest from parties in this project. Again, there is no contradictory evidence to that. That's in front of you. It's the direct evidence of Mr. Oates. It's found in paragraph 20 of his materials.
Where am I going to consider my opinion?
This would be, it's in the consolidated book. It would be Exhibit 7, tab number 5.
And what page are that?
It'd be page 56, the booklet. He says that he's been approached by 3 other parties who are prepared to develop the power generation waste management facilities in the lands upon rezoning. With respect to my friend's argument about this matter being frivolous, it is a serious matter. Considerable funds have been expended by REM on proceeding with the initial application. You know, there's a number of reports and a lot of work has been done since the application was instigated in 2013. And at best, we're down to perhaps one further report to deal with this matter, to suggest that Mr. Oates is free to come back to council at his leisure and wait another couple of years to go through the process again, probably with generating the same type of reports and using the resources of the municipality to evaluate and deal with this matter. You know, certainly, this isn't frivolous. We take Mr. Oates takes it very seriously. This is an important aspect. He's a owner of the property, taxpayer. So the reality is he doesn't want this thing, he doesn't perceive it as being frivolous or a waste of time. It's very important that it be dealt with. And again, certainly that to have this matter be dealt with, and given it's a very serious matter, it should be dealt with on a full hearing, not on a preliminary basis. It's important that, I think in the public interest, that a proper and just determination be made of the merits of the applications in front of the board. full and complete hearing all the evidence, pro and con.
We ask you to speak up, please. We are losing the back here.
Sorry?
We're losing the back here.
Okay, sorry. In terms of the grounds and reasons as set out in the appeal, they're very broad. They've set out a number of bases for the appeal. And again, I'm urging you that these are very important issues to all the parties and should receive a full and complete hearing. Subject to any questions you may have, Madam Chair.
Thank you. I do have a couple of questions. You may or may not be able to answer these, but just so the board has a better perspective on the appellant's position in terms of some of the submissions by Mr. Fairbrother. And right now I'm looking at the combined document, book exhibit 7, tab A. I believe it was part of your response to the motion record. And it is the application for the zoning bylaw and the official plan amendment.
Yes.
And I note on there, let me see, these are the requirements before an application for an official plan amendment, a zoning bylaw amendment, can be deemed complete. And I understand that your client attempts to assume the appeal of Entech-REM. Entech-REM, as you know, has served a response to the motion stating that it has no further interest in this matter. I look at things like drawings and plans and the requirement to submit 20 copies. A number of administrative things like that, certain reports that have been done, we understand not all the reports were complete. Those reports were commissioned by and paid for by whom?
I don't know. I can ask Mr. Oates if you like.
Well, I guess the question more directly, did Mr. Oates pay for them?
No.
Entech-REM. And is it your proposition that your client somehow has ownership of those studies and drawings to proceed with an appeal?
Yes.
That's your position?
Yes. It's the law of agent and principal. They do it on our behalf. They're our agent. Everything that they do with respect to that matter belongs to us.
And Mr. Fairbrother did draw the board to certain arguments that he puts forward in terms of Entech and their ownership of the project as proposed and presented to council. And I know you may feel differently about that, but specifically the board's question to you, and you have answered that, is whether your client believes that he minutia of that project and those things.
And perhaps the best illustration of it is the affidavit of Mr. Raisling, who was formally engaged by Entech and has in fact given us information and supported our
How
material.
is that proved to the board? I understand that he may have been or retained by Entech-REM to complete a study and then ended up having some conversation with your client with respect to that, and they expressed some opinion.
But he's under no obligation to cooperate with us unless we are entitled to the information, which he did. You know, he certainly provided information to us. He gave us an affidavit in support. Clearly, that's illustrative that the information belongs to us.
Okay. Mr. Fairbrother,
We have a moment. I just want to hear what Mr. Betches is saying. Thank you, Madam Chair. Madam Chair, in response to my friend's submissions, he began emphatically indicating who caused the problem. It's the municipality who caused the problem because they proceeded with that information. In my respectful submission, those submissions are completely irrelevant to, and I made that clear in my opening submissions, it's irrelevant to the relief that I'm asking the board for as a dismissal. Council, in my view, is not stopped from raising that issue if there was to be a hearing. If there's to be a hearing, we can argue that at that time. But this board is certainly not stopped from hearing all evidence, and you made that clear to Mr. Mazar in terms of the de novo function of the board. Frankly, council is entitled and did make its position known to the applicant last July, and the message was this use isn't wanted here. So there's nothing, no negative inference. If anything, council was absolutely clear. No negative inference to be drawn from that. My friend also indicates that his affidavit evidence documents that, it was the MOE who advised Entech you should withdraw your notice of completion. Again, it's irrelevant. It's withdrawn. Doesn't matter who told them to do it, whether they did it on their own initiative or MOE told them, it's withdrawn. And now, Entech-REM is gone. Mr. Mazar takes specific exception to the affidavit evidence of my assistant, Pam Orsborn, and yet he was unable to substantiate his submission that it is inaccurate. Because he spent some time on that, I want to, and because I take umbrage with that, I want to ask the board to look at the affidavit of Pam Orsborn, which is found in Exhibit 7, tab 2. And I will submit as an overview that this is purely factual. She has quite properly not strayed into offering any opinions, any conclusions. It was a means of putting documentary evidence before the board. And I will go through it, but very quickly. Paragraph 1, she's a legal secretary. I don't think that calls for a conclusion. 2, Entech filed an application with the board, and she attaches it as an exhibit, the full application. Nothing inaccurate or misleading about that. 3, she provides the municipal address for the lands. 4, from the application, she states what the acreage of the lands were. 5, Entech was listed as the applicant. It's all factual. 6, the application contained an authorization by Mr. Oates. Factual. 7, Entech-REM sought amendments to the OP and zoning bylaw to permit a power generation facility. According to the covering letter, the proposed facility was to use gasification technology, and then she attaches it. It's just a complete reiteration of the facts. 8, Municipal Council refused to approve the application on July 29th. It's factual. It would have been problematic if she did offer an opinion as to why it was done, but again, it's irrelevant why Council to this board. Of course, under the Planning Act 2.1, the board will give consideration to what the decision of Council was, but it's just a factor you take into account. 9, there was an appeal filed, and it's attached. And 10, Mr. Oates withdrawing his authorization. 11, the response from the solicitor for Entech-REM back in December. And 12, the MOE letters. There is nothing in that affidavit that isn't true or accurate. Mr. Mazar says, well, my secretary didn't explain why council refused. No, she didn't, and nor should she, but the grounds for appeal are attached as an exhibit, and the appellant explained why the council refused and that the position the appellant took with respect to that. Mr. Mazar suggests that I cannot draw an inference from the material that I filed with you that Entech-REM has a proprietary right. First of all, he is concerned that I provided this documentation to him this morning. This is from a report that he submitted to you, his client has access to, of September 2013. This isn't recent information. It's on the public record. It's been filed in the public and with the municipality. I simply looked at it to see if I could find anything about the nature of the gasification technology. And this board will recall I took you to page 10, which says that Entech-REM controls the North American license. Gee, that sounds pretty clear to me. For the Entech-REM trademark, it's the TM means trademark. That sounds pretty proprietary to me, and that is owned by them. So if Mr. Mazar doesn't like the wording that he finds there, then he had the obligation in his affidavit for Mr. Oates to provide evidence that the technology was transferable and that Entech was prepared to transfer that. He takes a step up towards that by saying, oh, well, Mr. Oates will continue with the application, there's other proponents, but he doesn't take that next step, and the obligation to call evidence on that was his. I'm asking the board to find that whether it's inference or fact, Entech-REM has proprietary control over this technology, and there is no basis to assume that someone can just pick up and run with it. That evidence was not put forward by the proponent because I suggest it doesn't exist. Mr. Mazar says that we should go forward with the hearing because considerable funds have been expended to date in reports and so forth. Yes, those are REMS funds that have been expended and they've withdrawn. Mr. Mazar talks about my submission that it should not go ahead on the basis to a full hearing on the basis that it's frivolous, which is a ground under the Planning Act. I'm not suggesting that Mr. Oates treats this matter frivolous. I'm sure it's a very serious matter for him. As I indicated in my submissions, it is a ground, and it would be frivolous in a way on the basis that it would be a waste of everyone's time to go through the process of setting up and then conducting a hearing with, as we stand before you today, not only don't we have a proponent, not only do we not have a project, we don't even have the prospect of evidence. There's nothing in the material to indicate that he will be calling Joe Q. Smith as a planner, and he's going to say this. You have no evidence. And at the appellant, if he's going to step into the appellant's shoes, he has the obligation to be ready to go and tell you what his case is going to be without getting into the substance. There is no prospect of any real evidence being brought forward. And I do have a case, if you'd like. I mentioned in my opening submissions about the decision of Chair Zudema, Vice Chair Zudema. If you would like that case, I can provide it to you, my friend. Do I have extra copies of it? Okay. Set this down for a moment. Okay. Mr. Mazar has a copy of this case. For the record, it's the case of Whitley and Guelph. It's a decision, as I say, of Vice Chair Zudema, May 2012. And you will find the relevant sections at paragraphs 15 and 16 of the decision. Madam Chair, you can read this at your convenience, of course, but I'll just paraphrase. Ms. Zudema is essentially saying that appellants have an obligation to be ready to proceed when we're at a pre-hearing conference. And an affidavit was filed by an Anthony Usher, who is a land use planner, but for reasons undisclosed and unknown to the board, the affidavit was wholly inadequate. It had no opinions to support the appeal. It only said that they can provide evidence to come forward. No analysis or specificity was provided. The board was left in paragraph 16 wondering what exactly this witness will say and what are the planning grounds. We're not even there yet. We don't even have the prospect of any witness, as I indicated. My friend Mr. Mazar suggested that the affidavit of Mr. Reusing, I hope I'm pronouncing that right, he said it was Riesling, but it's spelled Reusing, is proof that Oates can get access to the REM materials. With respect, you can't draw that inference at all. If Mr. Reusing was asked to provide an affidavit, he can provide an affidavit. He can't speak for Entech-REM in terms of whether they're going to have access to it, so you can't draw that inference. My last submission in reply is that, with great respect to Mr. Mazar, he did not offer any submissions to rebut in any persuasive way, or in some cases not at all, the grounds that I put forward to you for dismissing the appeal, so our request stands. Thank you. Subject to any questions you have, Madam Chair, those are my submissions.
The board does feel it's in a position to give an oral decision today. I do want to take maybe a 15-minute break and